If you're remarried in a common law relationship or part of a family where there's children from a prior relationship, a basic estate plan is often not enough. In fact, what looks simple on paper can turn into conflict very quickly after death or incapacity. Welcome back to Your Estate Matters. I'm Nicole Garton, President and General Counsel of Heritage Trust Company, and today we're talking about estate planning for blended families. This is one of the areas where I see the biggest gap between what people intend and what their documents actually do. A lot of couples think the answer is simple. Everything goes to my spouse and then eventually to the children. But in a blended family, a simple plan can create real tension. Your spouse may need security. The children may expect an inheritance. And if the documents are vague, outdated, or poorly coordinated, those competing expectations can turn into disputes. In this video, I'm going to walk you through the key issues, including tax on death, spousal trusts, joint ownership traps, separation and outdated documents, incapacity planning, and how to reduce the risk of litigation later. This is general education only, not legal advice, but it will give you the right framework to have a much better conversation with your lawyer, accountant, and trustee. Here's the core problem. In a first family situation, people often want the same thing. The surviving spouse is usually also the parent of the children, so the interests are more aligned. In a blended family, that is often not true. The surviving spouse may need the house, income, and long-term financial security. The children from a prior relationship may be worried that if everything goes out right to the new spouse, they may never ultimately receive what their parent intended. This is why estate planning for blended families is not just about who gets what. It's about timing, control, tax, and trust. Who can use the assets during life? Who controls the assets after the first death? When the children receive anything? What happens if the surviving spouse remarries, changes their will, or comes into conflict with the children? If your plan does not answer those questions clearly, someone else may end up answering them for you, and usually at the worst possible time. Let's start with tax because it drives so much of the planning. When someone dies in Canada, the Income Tax Act generally treats them as though they disposed of their capital property immediately before death at the fair market value. That deemed disposition can trigger capital gains tax on the terminal return. There is, however, a very important exception. If property passes to a surviving spouse or common law partner or to a qualifying spousal trust, the tax can often be deferred through spousal rollover rules. But those rules are stricter than many people realize. For a qualifying trust, the spouse must be entitled to receive all the income during their lifetime, and no one else can receive or use any of the trust's income or capital before that spouse dies. The property also has to vest indefeasibly within the required time frame, generally within 36 months after death, unless the CRA allows longer. That sounds technical, but here's the practical point. If you want a structure that says, my spouse can live off this, but my children get the capital later, that can work, but it has to be drafted properly. You cannot casually let children dip into capital during the spouse's lifetime and still assume rollovers will be available. There is also the GRE issue. A graduated rate estate can access graduated tax rates for a limited time, but that status only lasts up to 36 months following death. In a blended family, administration often takes longer because of mistrust, information disputes, or disagreements over the house, personal effects, or trust structure. Delay has tax consequences. So one of the first questions in a blended family plan is not just who do I want to benefit, it is what structure gives me the outcome I want without causing avoidable tax damage. Trusts are often very useful in blended family planning, but they are not magic. There are three common trust structures people hear about. The first is a spousal trust under a will. This can allow the surviving spouse to benefit during their lifetime, with the remainder passing to their children later. That is often the cleanest way to protect both the spouse and the children, provided the trust is properly drafted. The second is an alter ego trust. The third is a joint spousal or common law partner trust. Under the Income Tax Act, these lifetime trust structures are generally available only if the relevant age and trust conditions are met. That includes the rule that the permitted beneficiary must be entitled to all the trust income before death, and no one else may access income or capital before the relevant death. For alter ego and joint partner trust rollovers, the individual generally must have attained 65 years of age when the trust is created. Now, why do people use these in blended families? Because a trust can separate benefit from control. Your spouse may be able to live in the home, receive income, and be supported from the fund, but the capital can still be preserved for your children after your spouse's death. That can be powerful, but there's a downside. If your spouse is the trustee of a fund your children are waiting on, or if your child is the trustee of a fund your spouse depends on, you may be building conflict directly into the plan. That is one reason an independent trustee is often worth serious consideration in a blended family file. Not because family members are bad people, but because divided loyalties are real. One more point. I want to be careful not to suggest that these trusts make assets completely unchallengeable. That is too absolute. Trusts can contain certain estate litigation risks because the assets may not pass through the will in the usual way. But trust structures can still be challenged on other grounds, including capacity, undue influence, or the administration of the trust itself. So the better message is this: a trust can be an excellent tool, but only if the tax rules, trustee choice, and family dynamics are all thought through carefully. A lot of people try to simplify things by moving assets during life. Sometimes that helps, but sometimes it creates a bigger problem. Under Section 69 of the Income Tax Act, if you transfer property to a non-arm's length person for less than fair market value by way of gift, the tax rules can deem you to have received the fair market value proceeds anyway. In other words, you may trigger tax even though no money has actually changed hands. That matters in blended families because people often do things informally. They add a child to title. They transfer an investment account. They make a side promise about who will really get the house later. And then everyone tells a different story after death. Joint tenancy is especially dangerous in blended families because people use it for very different reasons. Sometimes it's meant as a true gift. Sometimes it's just for convenience. Sometimes it's supposed to just avoid probate fees. If the intention is not clearly documented when the transfer happens, you are inviting a dispute later. So if you're thinking about transferring assets during life by adding someone to title, do not treat it as a casual administrative step. Treat it as legal planning. This is one of the biggest practical issues I see. People separate, they remarry, they start a new common law relationship, but their documents still reflect an old reality. In British Columbia, the Wills, Estates and Succession Act says that if a will maker makes a gift to a spouse, appointed a spouse as executor or trustee, or gave a spouse a power of appointment, and they later cease to be spouses before death, those provisions are revoked unless the will shows a contrary intention. This is important, but it is not a complete safety net. Because not everything fixes itself automatically. Under BC's Power of Attorney Act, the authority of an attorney who is an adult spouse ends when the marriage or marriage-like relationship ends, unless the power of attorney says the authority continues despite that separation. So if you separate and do nothing, your old planning documents may partially unwind, but not in a neat, thoughtful way. They may simply create uncertainty. And beneficiary designations deserve special attention. They can create their own disputes if they're not reviewed and updated. The Supreme Court of Canada's decision in Moore v. Sweet is a reminder that beneficiary designations and insurance proceeds can become litigation territory when relationships change and expectations are not clearly managed. So if you're entering a new relationship, leaving one, or blending finances with a new partner, do not just update your will. Review everything. Your will, your enduring power of attorney, your representation agreement, your beneficiary designations, your trust structures, your title to major assets. People tend to focus on death planning, but in blended families, incapacity planning can be even more volatile. Why? Because when someone becomes incapable, there is no final will being read, there is just control. Who controls the bank accounts? Who decides whether the house is sold? Who pays the spouse's expenses? Who shares information with the children? Who gets access to records? That is why your enduring power of attorney and your representation agreement matters so much. And there's one detail from the BC regime worth highlighting. By default, an attorney's power to make gifts, loans, or charitable gifts is limited. The regulation sets the maximum at the lesser of 10% of the adult's taxable income for the previous year and $5,000 unless the document specifically authorizes more. So if your intention is that your spouse should continue to receive significant support during your incapacity, or that certain payments to your children should continue, you cannot assume the attorney has broad authority by default. Your instructions need to be explicit. Here's the stronger message. Do not just pick the person you love most. Pick the person or institution most capable of acting fairly under pressure. In some blended families, that will be a spouse. In others, it'll be an adult child. In others, it will be a neutral third party. What matters is not sentiment. It is whether the appointment will actually work when emotions are high and money is involved. Cohabitation agreements and marriage agreements are very important in blended family planning. They help clarify expectations. They can address ownership of property, excluded assets, and what each party intends to preserve for their own children. Under BC's Family Law Act, though, these agreements can still be challenged or set aside in certain circumstances, including where there was significant non-disclosure or other unfairness at the time the agreement was made. So the message here is not get an agreement and you're done. The message is get a properly prepared agreement as a part of a coordinated plan. That means full financial disclosure, independent legal advice, enough time to review the agreement properly, and estate planning documents that actually line up with the agreement. Here's the bottom line. Estate planning for blended families is not just about dividing assets. It's about balancing loyalty, fairness, tax efficiency, control, and family peace. And the hard truth is that the more people try to keep it vague in the hope of avoiding conflict, the more likely conflict becomes. Good planning does not eliminate emotion, but it does reduce uncertainty. If you're in a blended family, entering a new relationship, or trying to protect both the spouse and children from a prior relationship, this is not the kind of planning to leave on autopilot. At Heritage Trust, we regularly help families think through these issues and, where appropriate, act as an independent executor or trustee so the plan can actually be carried out the way it was intended. If this video was helpful, please subscribe, share it with someone who needs it, and use the booking link in the description if you would like to connect. Thank you for watching.